Hello everyone, I welcome you all to my YouTube channel. No, I welcome you all to my YouTube channel. Law Retention. In this particular video, we are going to talk about same-sex marriage, and we are going to understand how a law which came in 1961 got decriminalized in 2018. It is a term of 60 years, and in between we are going to understand 5 major case laws that proactively made a role in that transformation or decriminalization of that particular law of section 377, which is called unnatural offenses. And by the end of this topic we are going to also understand a particular case of Supreme Court which is prevalent nowadays, which is also known as Shreya Singhal versus Union of India. And by that case we are going to understand the perspective of Indian judiciary. So that's all. So let's dive into the video and understand all the concepts. Our first case is NAS Foundation versus Government of NCT Delhi, and this is the very first step which is taken for the autonomy of queer community. This case came in year 2009, and in this particular case the Delhi High Court decriminalizes homosexuality. So I will tell you the ground on which it decriminalizes, but firstly we will going to understand the particular section which is proactively involved in this case. The section was of IPC, which is section 377. Section 377 says only consensual sex or intimacy can be done between two opposite gender, not by the same gender. So it clearly criminalizes homosexuality or homosexual intimacy. So in this particular case the Delhi High Court decriminalizes homosexual intimacy, and the ground on which it decriminalizes was right to privacy and right to equality. On these both ground the Delhi High Court decriminalizes it, and we will give you some brief about NAS Foundation. So NAS Foundation is an NGO, a non-government organization, and it is working for queer community since 2001, for a long time. And after that, after this case it got a lot of backlashes because at that time society was not at that momentum to accept the fact that queer people has a right, and the society doesn't accept, but Supreme Court itself doesn't accept. We will going to understand why Supreme Court not accept Delhi High Court judgment in the next case. So let's move into the next case. As we saw in our previous case law, that was NAS Foundation versus Government of NCT Delhi. In that, Delhi Judiciary or Delhi High Court make a step forward for the autonomy of queer community, but in this particular case we came a step backward, and we will be at the position where we were at the beginning. So this case is referred as Suresh Kumar Kaushal versus NAS Foundation. In this particular case, the Supreme Court gives 3 directives. The first one was, and this came in year 2013, and Supreme Court says that the court does not have a power to change any law. It is a work of legislature. So you better go to legislature for the transformation of law or to decriminalize any law. And it also says that there is no discrimination because we are creating inequality on the basis of on the backup of a law, which is section 377 itself. And in the third directive it says that a queer community is in very small fraction, and this very little fraction of people, and the judiciary has not is not liable, is not ready to protect a right of a very small fraction of people. Why are you abusing judiciary? We are coming with the next case law. Wait for bro. Our third case is National Legal Service Authority versus Union of India. This is very famous because it gave the recognition to the third gender for the first time. And in this particular case, which this case came in year 2014, but in this particular case it gave a distinction between biological sex and psychological sex. Biological sex is something which you can determine by the birth itself. But in the psychological sex, it is about how you refer yourself, how you put yourself into the uh, gender ideals. And and by that case, if you are filling any university form or any application form for UG, PG, anything, you get an option of third gender in the sex distinction. So when you fill your form, you find the third gender option, and this option, this framework came by the NALSA case law in 2014. So let's move into our fourth major case law. Our fourth major case law. This is very famous in our generation, particularly among Gen Z, because the whole day of Gen Z generation goes like, I need private space. I need privacy, please. So the case referred as Justice K.S. Puttaswamy versus Union of India. It came in year 2017 and it was constituted by 9-judge bench. And the particular agenda and the main point of this particular case was to determine whether right to privacy is considered as a fundamental right or not. So, as you can remember, in our second case, we have discussed about Suresh Kumar Kaushal versus Union of India. In that particular case, the Supreme Court of India held that we cannot protect the rights of a small fraction of people or a community. So, in this case, D.Y. Chandrachud, our current CJI, said that in that case, we have to consider right of minority, and we cannot justify ourselves by saying that they are in a small fraction, so we don't we are not bound to protect their rights. And they also said that LGBTQ community, showing LGBTQ community and hostile treatment, giving them hostile treatment is impermissible, is not permissible. And in this particular case, the right to privacy is also been extended to several levels, but the main point of right to privacy is extended to sexual orientation of a person. So every person has a right to privacy owns about her own or his own sexual orientation. Our fifth major case law is Navtej Singh Johar versus Union of India. This case law is widely famous because it fully decriminalizes homosexuality in India. It constituted in year 2018 by 5-judge bench, which is also referred as constitutional bench. And the major articles on which the grounds are justified for the decriminalization of homosexuality were Article 14, 15, 19 and 21. So we are now going to discuss the most recent case, which is Superior Chakravarti and another versus Union of India, which is also referred as Superior versus Union of India, which came in 2023 itself. And in this case, a 5-judge bench was constituted because of the substantial question of law on the interpretation of constitution. Substantial question was put on three major laws: Hindu Personal Law, Special Marriage Act, Foreign Marriage Act. And the court and the judges selected Special Marriage Act because they didn't want a conflict with any personal law. The main question is whether in Special Marriage Act the homosexual couple has any right to marry. And Special Marriage Act clearly mentioned only heterosexual couples have a right to marry with each other, and this hampers several rights of homosexual couples like surrogacy, adoption and employment benefits, and they cannot open joint account in banks. And the question is right to marry, whether they can marry or not. And according to right to equality, freedom of expression and privacy and dignity, they should have. But in India, the marriage is a sacrament and it didn't consider any homosexual marriages at all. 2015, the US court passed a landmark judgment which is referred as Obergefell versus Hodge. And by this case, the right to marry was given to all the homosexual couples in US. The ground on which this case law was based was due process of law and equal protection of law. And if we compare this case law Obergefell versus Hodge to our case law Superior Chakravarti, we fail by two reasons. First, right to marry is not a fundamental right in India, and the reason and the justification the court provide that everyone does not have a right, does not have a choice to marry whichever they want. And the second point is separation of power. The court says that the amendment and the law formation duty is of legislature, and the court will not interfere in it. And if you really want to change or really want to have a law for homosexual marriages, you can refer to the parliament itself. Thank you for watching this video till the end. I really appreciate if you like and subscribe to my channel, and I will be coming with such new videos in the future. Till then, bye bye.